I'll be starting with the three threats to your legacy because understanding these threats will help you create a living trust that will address these threats. And then we'll go into the 4 steps to creating a living trust without the high cost of attorneys. You'll also have a chance to consider 3 ways to create your trust. And if working with an estate planner like myself will help you get there quicker and more affordably, I'll make sure to leave time for Q&A. Okay, so that's our agenda tonight. We've packed a lot tonight, so I'm just going to get started. Most of us spend our working lives creating this beautiful cake, this legacy that we've accumulated for our children or our beneficiaries, not realizing that there are many unwanted guests with forks in hand waiting to take a bite of our cake. If we don't plan properly, it may get to them with a big chunk missing or a slice left, or worse, by the time it gets to the grandchildren, it's just crumbs. In tonight's webinar, I want to show you what you can do to preserve this legacy, to keep it as intact as possible for your children, for your beneficiaries. So who is trying to take big bites of your cake anyway? That's what I'm referring to by the 3 threats. Let me introduce you to my mother-in-law, Alice. She's showing off her manicure, by the way. So unfortunately, we lost her during the pandemic. We all flew to Texas for a beautiful memorial service for Alice, and we're glad to know that she had a will, but not a trust. So the first surprise that my husband, her eldest son, got when he was hoping to wrap up the estate after the memorial service, the first surprise was to find out that it will take the court 2 weeks to approve his executorship. And until then, he cannot remove funds, he cannot sell the house, the assets were frozen. So he and his siblings had to negotiate how to upfront the funeral arrangements, the memorial service, the attorney fees, the probate attorney fees. Not only they couldn't sell the house, but one child was still living in the house and really dragging her feet, moving out. My mother-in-law left 2 pages of personal item bequests. Note to self, try to give away as much of my stuff before I die, so I'm not making it complicated for my children. But because it was a probate, my husband, the executor, had to keep very good records about where each bequest went because he had to give an account to the judge. Not only that, anytime you have a probate, the court is going to have lots of reporting requirements that you have to abide by. As a result of all these delays, the house missed a hot, post-pandemic, if you remember, seller's market. They did finally sell the house, but it had gotten a bit run down because nobody wanted to invest more money in the house, and so they couldn't sell it at the top dollar. On top of that, because my husband found out that he could not start the wheels moving until his executorship was approved 2 weeks later, he had to come back to work and then return for a couple more trips. And that was time off work, some of it unpaid. So after this experience, it really made me realize the importance of trying to avoid probate. There are 2 options you have when it comes to leaving your legacy to the next generation. One is a public court control process that I just went through very briefly. It's also known as probate. So everything is supervised by the court because there was no living trust. So the court stepped in to oversee the transfer. The other way is through a private family contract, also known as the revocable living trust. Big difference. One is in a court, court orders, code numbers without any context. And the other is in your family living room, perhaps the same one where you had tea with, your parent who passed away. Huge difference. This is a recent Forbes article that talked about the cost of probate. On average, it takes about 20 months to wrap up probate. You're at the mercy of the court timelines, especially at that period when COVID was just over and the courts were just starting to open. There was such a backlog. But the point is that you are at the mercy of the court's schedule and timelines. And it costs between 3 to 7% because of probate fees, court fees, assessment fees. So let me put that number to a reality check. Say you have a nice round number for your estate, $1 million, and your probate went smoothly. No surprises, no family fights, no glitches. So you hit the low end of the cost, 3%. 3% of $1 million is still $30,000. That's money that could go to, the spouse's retirement or the grandchildren's college fund, not to the system. That is the first threat that I'm referring to, the delay, stress, and cause of probate. Threat number 2 is even worse than probate. It's family fracture. You've heard stories of families inheriting money, a good thing, right? And then you hear that they stop talking with each other and you shake your head and say, oh, that's just too bad. Well, the same thing can happen to our family, our beneficiaries, if we don't understand the causes of family fracture at a time like this. The first is usually if they have to go through probate. You can expect stress, delays, fees of probate to cause a lot of emotional stress, but probate is also public. You have people who say, oh, I trust my kids, they will sort it out. What about their spouses? What about their siblings? What about other people? Because probate is public, these people suddenly feel free to whisper in your kids' ears, you should have gotten more, you spent so much more time with your mom, etc., etc. And like I said, court processes are, no context, much less personal. But the reason that you have more family fracture in a probate situation than with a living trust is this. Probate is a ready-made venue for disputes. The judge is there. A complaint system is already built in. Attorneys are lined up. All it takes is for one, it doesn't even have to be unhappy relative. All it takes is for one relative to be confused and she starts hiring her attorney to see what's going on, which makes things worse, slows things down even more. It just escalates from there. So probate is a big cause of family fracture. The second cause is the family home. Don't treat the family home as just another asset. It's an emotional asset. It's Christmas mornings, it's baking cookies with mom. It's all these emotions that go along with the grief of the time. It's unequal and it's very hard to split a house. I had a client who offered to buy out the parents' homes, but one of the siblings insisted that putting the home up in the open market would fetch a higher price. So yes, it did. And in the end, a stranger, got the home, but it just caused a lot of unpleasant tension among the siblings. The third cause of family fracture is surprises, hidden accounts, unexpected debts, or parents telling their kids different things, last minute changes. Because with this, the beneficiaries are all just left wondering, was mom pressured? Is this really what she wanted? So that's the second thread when you uh, think about putting your estate plan together. And to me, this is the costliest thread. It would be so devastating for me and my husband to think that, if we pass away, our kids will stop having Thanksgiving together. They'll stop talking with each other. That's, to me, the costliest cost. What do you think is threat number 3? A lot of people think it's death taxes. Is it? Let me just quickly give you an overview of the taxes that get involved. First is the estate tax. That's the tax that the government imposed on the person who passed away, on the estate. Of course, he's not around to sign a check to the government, so it's taken out of the estate. That's why it's called the estate tax. It's very high. Federal, it's 40%. That's almost half your life's work, siphoned to the government. Fortunately, the exemption limit is very high, 15 million. They're after the big whales. The second type of death taxes is inheritance tax. This is tax imposed on the recipient, the person receiving the inheritance. Good news, in the US, there is no inheritance tax at the federal level. So if a long-lost uncle suddenly surfaced somewhere and you got a huge inheritance, it's 0% inheritance tax, okay? The third tax is capital gains tax. Say you purchase your home for $300,000 and now it's worth $1 million. If you were to sell it today, you would have to pay capital gains tax on all that profit. But if it goes to your kids, the cost basis steps up so they could sell it the next day after I pass away and pay 0 capital gains tax. Now, don't forget, every tax has a federal level and a state level. There are 13 states that impose an estate tax, but they're not at 40%. They're at maybe 10 to 20%. Inheritance tax, only 2 states, Pennsylvania and Nebraska, impose an inheritance tax on children, on direct offsprings. All other states either do not have an inheritance tax or it's waived for direct offsprings. And the capital gains tax, same thing, it steps up. So let's see how death taxes play out for Mike. Mike's father, they both live in Florida, left him quite a sizable inheritance. A house, IRAs, a life insurance policy, a rental property, and some stocks that have appreciated a big deal. All in all, $4.5 million. But Mike's reaction wasn't, yippee, I struck the lottery. His first reaction was, I'm going to be hammered with taxes. Will he? Let's check it out, okay? Let's look at Mike's tax bill. First, the federal level. Well, the federal tax exemption is $15 million. $4.5 million isn't even a third of it. So no estate tax. Inheritance tax in Florida, 0. And capital gains tax, step up in cost basis, 0. So no federal tax. Let's look at the Florida state taxes. Guess what? Florida does not impose an estate tax, no inheritance tax, also 0. So a $4.5 million of inheritance, 0 taxes. What if Mike is unlucky enough to live in one of the states that have an estate tax, like my state, Massachusetts? We have one of the highest estate taxes. So let's see what will happen then, okay? Massachusetts, has an estate tax on anything that is more than $2 million. Fortunately, it's not 40%, it's 8%. So it's 2 million exemption per person. So if you think of Mike's, 2 million from his mom, 2 million for his dad, 4 million. So he's only over by $500,000. And 8% of that is just $40,000. So even if he live in Massachusetts, his $4.5 million inheritance, the estate tax is only 440,000. So here, just for your information, there are only 13 states that charge an estate tax, and a lot of them have very high exemption. Connecticut, the exemption is 15 million. Only the ones that I highlighted in yellow have exemptions of 3 million or less. Oregon has the lowest exemption. So anything you leave above $1 million in Oregon will have an estate tax. But that's one state out of, 50 states. So here's the bottom line. Death taxes is not going to be a threat for a lot of people. Okay, so what is threat number 3? Threat number 3 is inheritance wealth erosion. What do I mean by that? Let's say your legacy, your assets, your entire estate made it past probate. Okay, it made it past probate. It also, the family didn't fight. The family stayed together. They're still having Thanksgiving dinner together. And you also had 0 death taxes. And so your entire estate made it to the beneficiaries or to your children intact. Well, a new set of risks show up. What do I mean? Dangers to our heirs' inheritance. Have you heard of the lottery winner's curse? Many lottery winners lose their winnings after a few short years. In fact, some of them are worse off than before they won the lottery. The same thing can happen to your children if you don't prepare them, because too much money too quickly without guardrails just make you do stupid things. I maybe would do stupid things myself. That's one. High risk ventures. This is the opposite. These are children who feel so responsible about getting their parents' inheritance that they feel pressured to grow it. So they get into high risk ventures that they don't know much about and end up losing their shirts. Are your children in high-risk professions such as surgeon, attorney, where lawsuits and professional, liability is more common? So that could also put the inheritance at risk. Potential divorce. Let me be clear, inheritance is not considered a marital property. It's considered a separate property. However, after many decades of being married, it's very easy for it to get commingled. Let me give you an example, okay? Say money is tight this month and you think, I have all this inheritance money, sitting in the bank. Why don't I just use it to cover this month's mortgage? Very nice thing to do. Well, you do that a few times. In the event of a divorce, that inheritance will be considered a marital property because you use it to support a marital asset, the house that is jointly owned. So at the event of a divorce, the other party's attorney could argue that's a marital property and half of it could walk out with the ex-spouse. Heirs passing away. So the story that made me put that in was this young man inherited quite a sizable inheritance from his parents when they pass away. However, unfortunately, before this young man had a chance to create his estate plan, he passed away. So by default, all his assets went to the closest kin, which was his wife, who remarried a few years later and had, a new family. So in essence, that all that inheritance just left the bloodline. So this is what I mean by the third threat in wealth erosion. This chart is produced from data from 3,200 families. It shows that by the second generation, only 30% of the inheritance is left, and by the third generation, only 10%. So when I use that cake illustration, a slice or crumbs, I really wasn't exaggerating. This kind of data and experience is where you get quotes such as shirt sleeve to shirt sleeve in 3 generations. So an immigrant comes here in nothing but shirt sleeves, work really hard, makes a lot of money, but by the third generation, back to shirt sleeves. If I told you that there was one simple thing you could do to safeguard yourself from these 3 threats, probate, family fracture, wealth erosion, would you do it? My guess is that you would. Well, the answer is a living trust. So we are here in the agenda, talk about the 3 threats, and now I'm going to go into how a living trust protects you from those threats. A revocable living trust that's done right doesn't just protect you from probate. It also keeps the family whole, and it preserves your children's inheritance from those wealth erosion risks. In the interest of time, I'm just going to quickly gloss over the first 2 because I have a lot of videos on it. The reason a living trust protects you from probate is because you've transferred your assets into the name of the trust. So the assets are no longer in your name. So there's nothing for the court to supervise, because all probate is the court wanting to make sure that your assets that's still in your name are being transferred to the intended beneficiaries, since you're no longer around to sign off on the transfers. The process of creating a living trust just makes you be more thoughtful, anticipate more issues, and document things more clearly, so that just by going through the process, you have a higher chance of avoiding family disputes and family confusion, family fights. So now I can spend more time talking about how a trust preserve your children's inheritance. So first is, when you have a trust, you have the ability to stagger the inheritance. If you say designate your daughter as the beneficiary of your brokerage account, then at your passing, the brokerage account will write one big check, one lump sum for your child. A millionaire overnight, whether she's ready or not. With a trust, you can specify at age 30, I want my children to get 1/4 of my inheritance. At age 40, I want her to get, the rest. So it gives her a chance of going through the school of hard knocks. That alone, waiting for your children to be more prepared, helps them be wiser about their money. The second reason is that you have a trustee. If your child is a good manager of money, some of your children may be accountants, then you can assign them to be trustee of their own children's trusts. If not, you could assign an older, wiser relative, like an uncle, somebody who has more wisdom and can guard against wealth erosion. Now, just because the children are not getting the money until they're 30 or 40 doesn't mean that they have no access to it at all. The IRS states that even before they reach these distribution age, if they ever have a need that they coin HAMS, because it means if they ever have a need around health, education, maintenance, or support, the trustee can release funds from the trust for those needs. So if your child is injured, there's a medical situation, or if she decides to get a master's degree, or if your child lost a job, the trust is there to support them even before they reach distribution age. Okay, so I think this is the best of both worlds. So now let's talk about the 4 steps to creating a living trust. This part may be a bit intimidating for you because you may think only, an attorney is trained to do this. So I want to just help you relax and think of these 4 steps as building a home. Okay. Step 1, key decisions. Before you even knock the first nail to build your house, you want to think of the big parameters. Is it going to be a 2-bedroom house or a 4-bedroom house? Is it going to be an open layout, or are you going to have the master bedroom on the first floor, second floor, that kind of thing? That's step 1. Step 2 is finding a team, qualified, reliable team to build your house. And the 3rd step is to make sure that it's signed off, it's approved, so you can go to the 4th step, which is to move into the house. Now you may think, yeah, duh, the reason you build a house is to move in. But you'll be surprised how many people spend money and time creating a revocable living trust, and then they forget to transfer, or they weren't told, or whatever, to transfer their assets into the protection of the trust. They will end up in probate, and it's not the trust's fault. Okay? All right, now let's drill down into each of this step, okay? When it comes to your estate plan, what are the key decisions you need to make? First is you need to decide if you're creating a joint trust or separate trusts, separate individual trusts. They're blended families where they have different beneficiaries, different successor trustees. They may want individual trusts. In general, if it's your only marriage and your children are all shared children and you file your taxes together, it usually means a joint trust. But this is one of the key decisions you need to make. Distribution to beneficiaries. What ages do you want your children to receive their inheritance? Who will they be trustee of their own trust until that distribution age, or will it be a relative? Or perhaps you may want to hire a professional trustee. Until they receive their inheritance, can they direct their trust assets to folks outside the family or only within the bloodlines? So these are some decisions you'll be making before. Even if you're thinking of working with an attorney, these are still important key decisions you want to start thinking about before you show up in their offices. Key successor roles. They're important roles that will step in when we're not around, okay? Healthcare proxy. If I am incapacitated, who will speak up on behalf of my healthcare preference? So this is not when I pass away. This is if I'm in a car accident and I am incapacitated, or I have dementia and can't think for myself. Power of attorney. What about who will be making your financial decisions on your behalf if you are incapacitated? So these 2 documents, your healthcare proxy and your power of attorney, these are for events of incapacity. If I pass away, these documents are moot because there's no healthcare decisions to be made, etc. So successor roles. If you have young children, who will step in as a guardian of your minor children? And most importantly, successor trustee. Who do you trust to carry on the instructions in your living trust? So these are just some key decisions in step 1 that you'll be thinking about when you embark on this journey. Step 2 is picking a team. If you're not working with an attorney, you'd be using an online platform, and you want to make sure that it can support, it has these features. First of all, should be easy to use. yet flexible and powerful because it has to protect you against those three threats. It's attorney drafted. It's not cobbled together by AI or just, jumbled up together from different pieces, but it's drafted by attorneys, and that it's tailored to your state because every state has different requirements. There should be not just live chat and email, but also phone support because for many of us, it's our first time doing this. So having someone to talk to on the phone is really important. Are there audit checks? Are there summary reports that allow you to review your trust very quickly? And also, without mention, it should be encrypted. It should be secure. Never put your bank account information in the trust. That's not the kind of security I'm talking about here. I'm talking about data security because your trust does have important information that you don't want to go public. It's system security. In terms of bank account information balances, you should never have that in your trust. Okay. So these are the things that you look for in an online platforms to make sure that it's going to build you a robust living trust. And these days, this kind of I just want to show you an example of how a platform like that looks like. The platform I work with is wealth.com. It's question-based, so the user interface is pretty easy to use because it's question-based, and yet it's powerful enough to be customized to your specific situations. It also has summary reports. I like to emphasize how important these are because do you know why so many estate plan documents lie, in cabinets, drawers for decades without being reviewed, even though tax rules have changed, family members have come and go, but they're not updating their estate plan because nobody is thrilled at the prospect of going through 60 pages of legalese, or they may fear having to contact the attorney for another round of sticker shock to make updates. When you have a summary, a review of the key decisions in your trust, it allows you once a year, once every 2 years, to just quickly at a glance review your key decisions. So anything that has changed can pop up, more easily. That's why I make it a point to mention how important these summary reports are. The platform should also provide you with a signature checklist, which documents needs to be signed by whom, needs to be witnessed and notarized. Every state has a signature checklist that looks different because every state has different requirements. So make sure that you follow the signature checklist religiously because a document that's not signed or that's not witnessed when it should be or not notarized is an invalid document. It will not hold up in court. So that's step 3, making sure it gets signed off and approved. Now we go to step 4. Oh, this is just a hack that I tell my clients before you go to the notary's office. Just get a yellow sticky or these tags and flag all the pages that need signatures, witnesses, notary, so that you're not, at the notary's office flipping through 60 pages of legalese. That's how you're going to miss some pages. Step 4 is the funding the trust. It's transferring assets into your trust. You're transferring titles of probatable assets. Not all assets should go into a trust. And you will understand this more, which assets are probatable and which are not. Even though the assets will be owned by the revocable living trust, you are still the trustee. You're the initial trustee, which means you have full control You can put your house in here and you can decide to refinance your house, or you can decide to sell your house. You can buy another property in the name of the trust and put it in here. You can dissolve your brokerage account. You're still the boss. But those assets are no longer in your name, but they're in the name of the trust. So when you pass away, there is nothing for the court to supervise because you don't own them anymore. That's why, by the way, a will does not avoid probate, because a will is essentially a letter to the judge. I want this person to get this, that person to get that, but those assets are still titled in your name. So the courts need to oversee the title transfers. I know probate gets a really bad rep, but its essential core purpose is to make sure that transfers happen to the intended beneficiaries, because you're no longer around to sign off on those transfers. All right, now we're going into 3 ways to create your trust. Wow, I've covered a lot. How's everybody doing? Good. We will have time for Q&A later if you want to put it in the chat or make a note. I know this is a lot of information, but I also know that a lot of you, if you've been following my videos, you are probably keeping up with it really well. Okay, 3 ways to create your trust. Well, you know the first 2, going with an attorney or do it yourself, or you sign up with an online course. And many of you perhaps have tried one or the other or both, but perhaps you haven't heard of the 3rd way. It is to work one-on-one with an estate planner, to partner with a one-on-one guide. So you don't have the high cost of attorneys, but you're getting the support for your specific situation that you don't get with, doing it yourself. So on the next slide, I'm going to show you what that's like, because it's probably new to you. So our team, we call ourselves estate plan partners. The program we have is an all-inclusive one-stop program. When you work with us, you're not having to, cobble together different components. It includes everything you need. One is your certified estate planner guide. You'll never feel like you're stuck by yourself because we're there for you. The second is the platform to draft the documents, the wealth.com platform. You can check out the quality of this platform by going on the website. However, you will not be able to sign up on your own because the wealth.com is an advisor-only platform. You have to go through a financial advisor or a certified estate planner because it's a very robust platform. So it needs, you really need a guide. And the third part is a library of shortcuts, checklists, and resources that will just enable you to go through the process a lot quicker, just a lot of shortcuts. Let me talk about the process of a client that works with our program. So a typical process timeline is about 4 to 8 weeks. It starts with a one-on-one onboarding meeting with their certified estate planner. By the end of this one-on-one onboarding meeting, they have a draft of their revocable living trusts. Okay. It's intentional that it's not completed in this first meeting because you really want to take time discussing it with your spouse, maybe with your adult children, maybe with your accountants. You want to really review and ruminate before you finalize the estate plan. Then we meet again and talk about trust funding. This is the process, if you remember, of transferring your assets into the trust. Not all assets belong into a trust. You don't want to make a mistake, for example, of transferring your IRA into a trust that would just trigger withdrawal penalties and taxes. And then you would have instructions, directions on how to execute those trust funding steps, because I can't go with you to the bank to, transfer your bank accounts or to record your house deed to your county's recorder's office. The end point of this process is for you to have these documents in place: your living trust, your pour over will. Pour over will is not like your standard will. It's a will that goes along with the trust, because if there's any asset you forgot to transfer into the trust, the pour over will tells the judge, my intention is to pour over everything into the trust, so it makes the process smoother. The healthcare directive and the power of attorney, 4 documents. That's the 4 essential documents of an estate plan. So this is a typical process. Of course, things happen and families get delayed, but this is the process. Now let's talk about costs, because costs can be a real barrier. When I talk to families, what's keeping them from having their plan done? Absolutely, it's not because they don't realize how important it is. They do realize, but they would pick up the phone, call an attorney that's referred by a friend, and then they get sticker shock. And then suddenly it's like, oh, maybe next year we'll proceed with this. So cost is a real thing. That's why I want to address it. So cost comparison, probate, definitely don't do nothing because you saw that how expensive probate can be, not to mention all the other things like stress and family fracture and all those things. Going with an attorney, depending on where you live, to get a complete estate plan of those 4 documents could be $3,000 to $5,000. The 2 common do-it-yourself platforms out there are LegalZoom and Trust and Will. They cost about $500 to $600 with a 30 days. So you got to chop, okay? Get everything done by 30 days. Otherwise, you have to pay a continuation fee and that does happen. I work with a client who said that he actually paid them twice, and still both times he procrastinated, and the 30-day, deadline came and went. So these are the cost comparison. So let me ask you, with the option of a one-stop, plan of having a one-on-one guide, a robust estate planning platform that was created for advisors and certified estate planners, and all the library of resources and shortcuts and checklists that comes with the plan, what would be a fair investment? Well, I can tell you what a couple clients told me. They said that after having gone through the process and worked through the wealth.com platform and experienced the one-on-one guidance, they said that the most valuable thing they got out of it was their own growth in estate planning. Like they actually understood, what their options are, what their plan is. Unlike working with an attorney and getting a beautiful leather binder at the end, 60 pages of legalese, and you're just hoping that the attorney understood what you wanted. So that was what, the value they got out of it. And for that value, they said that it was worth as much as working with an attorney. Fortunately, it doesn't cost anywhere near that. So this plan costs $795 for a couple, and $695 for a single person. And because you attended this webinar, if you take action by Monday midnight, that's next Monday, you can use this promo code and slash $200 off the price. Some of you may wonder, like, Myrtha, you're so generous with your resources or your videos. Why are you putting a deadline on us? If you want to give the discount, just give the discount. That's a really good question. It's because I see that part of my job is to nudge you along this process, is to give you incentives to get this done, because this is one of those things that's important, but not urgent. And I feel that I want to do as much as I can to give you incentives, especially when I get this kind of feedback from my clients. This one client said, I completed my estate planning documents. Thank you for lighting a fire under me. This other letter was, I held my breath until I finished reading it, because this couple that I was working with, the email started with, my husband passed away. And I was so relieved to find out that they had, gotten everything notarized. So when I read feedback like this, I feel that it is my job to nudge you along. With the $200 discount, it costs a couple $595, and for a single person, $495. And to incentivize you even more, I have bonuses. The first bonus is this this ebook of estate plan checklists. So many of my clients, ask me the same question over and over again: how to choose a healthcare proxy? How do I make sure that, I've chosen a good executor? Or what are the assets that should go into a trust and what should be left outside the trust? So I decided to just compile all these questions into this checklist to save you a lot of time from researching and having to do the homework yourself. That's bonus number one. Bonus number two is lifetime unlimited edit access. Okay, not 30 days, not 60 days. 2 years from today, you have a new baby in the family that you now want to include, part of your beneficiary list. All you need to do, you don't even need to call me. You just log onto the wealth.com platform to make the changes. You will have to reprint the trust document and get it re-signed, re-witnessed, re-notarized, but you're not having to call an attorney and, having to pay an attorney to make those changes. Unlimited edits. The caveat here is, of course, it's as long as wealth.com and myself are still partnering together. Bonus number 3 is a complimentary wealth.com account. Do you have family members who still believe that a will is the only way a will is good enough to avoid probate? You have this bonus allows you to get a complimentary wealth.com account, plus all the resources, worksheets, scripts, bonus number 1 and number 2, also lifetime unlimited edits for someone you care about, so they also can bypass probate. The only caveat here is that you can only do this after you complete your own estate plan, because I don't want you to get distracted by, getting someone to into the process. So once you've completed your plan, you will get a complimentary wealth.com account that you can give. So it's like 2 for 1. Okay. How do you work with me? So the website is estateplanpartner.com. And this is the one thing you want to jot down: Trust 200. When you go to this website, you have a choice. Let me move here so you can see. You have a choice of choose the single plan or the couples plan. And then on the payment page, remember to put in the promo code, so it takes $200 off. And that will take you to a scheduling page for us to schedule our one-on-one onboarding. By the end of this onboarding, you will have a draft of your revocable living plan. We're not here to give you more information and to increase your knowledge. We're here to get your plan done. Okay, so here's a summary. With the promo code, it's $4.95 for a single, $5.95 for a couple. What you get is a one-on-one guide. The wealth.com platform is also included, and the library of resources, shortcuts, checklists. The bonuses, you get the book of estate plan checklists, lifetime unlimited edits, and a wealth.com complimentary account for a friend, a family member. I hope you've learned a lot, whether you choose to work with me or with an attorney or bravely do it yourself. I hope this has been a helpful webinar. Now I'm open for questions.